that would be very wrong. On the process have been said on them. And all this, right, we've been following. In fact, we know that so how to say that we wanted to proceed on the last technology. Because somebody looking at the 5 years in service. And after that, we started to almost 50 years, 19 years. That's why we know this matter again, we don't do that yet. And Lord, for the self-dependent, we say, the Lord should wait for him until the new vacation, then we will file their defense. You know, it's not something that is something at all. If they are filed, we have to see what they are doing.
Yes, counsel, don't waste time. I said, what do you want? Mr. Abu, I have listened to you.
It's not that it was a newspaper. I did not by any means make any application for this possibility. I don't simply say.
I say I have heard you.
Yes.
Yes.
You know, for hearing, definitely hearing of this matter. Since the first defendant has no defense to this case.
Give me this.
We have the debate, and I think if you refer to my identity, you cannot refute that part. That's why my position was that at the next assembly with my part, we can be forget this settlement has failed.
This case is hereby adjourned to 28th of October 2025 for hearing. Right, which one is your case? Which case is that? Why is it difficult for you just to bring case file? All the case.
Number NICN /55/2024 between Mrs. Ekane Eyenemi and 1, University of Calabar, 2, the Vice Chancellor of the University of Calabar, 3, Pension Transitional Arrangement Directorate, 4, National Pension Commission, 10-4. My Lord, the claimant in court and defendant is defended by Yedman.
Appearance?
With all respect to my Lord.
Yes.
Go out of what I aspire. There will be we are clear for example.
Yes.
With profound respect, my Lord, journalists who have worked and years with and the human camp about our guarantees for the first and the second defendant.
Yes.
Respectfully, my Lord.
Yes.
A
Yes.
Although this matter was report of chemical substance.
Yes. How far have you gone?
And along we have been talking to reasonable development support, and we still have the position where the defendant must find their color. Although we have the program, give it the author.
So what do you want now? What do you want? What do you want?
Although we apply that the defendant should sign their color so it will be properly followed by law.
I can't ask them to sign. Is it not settlement? Is if they agreed with what you have proposed to them?
I think it's a reasonable proposal, we are not okay.
That one is between you and them. If you agree, you sign the terms, file it, then you adopt it as.
Yes, no, that's what we did. I don't go to the chance. It's a reasonable proposal. So, we are asking for a short day to be able to, because I've talked our chance. About the claimant has suffered over 2 years.
We don't have any date. We are starting vacation on Monday, so the date we have is after resumption. Give me date. Find an early date, please, for me. But try to finish all what you want to finish and file the term before the next adjourned date. This case is hereby adjourned to 15th of October 2025 for adoption of terms of settlement.
Between 1, Joseph Fernandez. 2, Moses Alofa. 3, James Opere. 4, Mirabel Odu. 5, Polika Itopen. 6, Benjamin Bassi. 3 for themselves and on behalf of the abandoned and wrongfully terminated workers of Cross River State Waste Management Agency. And 1, Governor of Cross River State. 2, Attorney General of Cross River State. 3, Commissioner, Ministry of Environment. 4, Chairman, Cross River State Waste Management Board. 5, Cross River State Waste Management Board. 6, General Manager, Cross River State Waste Management Agency. 7, Cross River State Waste Management Agency. 8, Cross River Government of Cross River State. 9, Ministry of Environment, Cross River State. My Lord, the claimant are in court and defendant absent.
Appearance. Yes. AO.
With all due respect,
Yes.
EJ asking for E dot J.
You say?
E dot J. Execute. Appear with me in Boko Evan. Execute. My Lord, the master appears for all the
OO a bank.
Yes, ma'am.
Okay. This matter is for judgment. The judgment of the court goes like this. By the general form of complaint dated 11th of June 2020 and filed on the same date, accompanied by statement of facts, witness statement on oath, list of witnesses, list of documents to be relied on, and photocopies of documents to be tendered as exhibit. The claimants praise the court for the following reliefs. They are a declaration that the failure refusal, or neglect by the defendant jointly and severally to issue complainants and about 200 other such workers letters of employment when they were employed is wrong and illegal. B, a declaration that the defendant jointly and severally ordering the complainants and about 200 other such workers of the seventh dependent Cross River State Waste Management Agency orally to stop work and thereafter abandoning them without work and to pay since June 2016 is wrongful and illegal termination, and it is unconscionable, vexatious, wicked, wrongful, and a breach of contract of employment. C, a declaration that the failure, refusal, and neglect by the defendant jointly and severally to pay the complainants and about 200 other workers' salaries for the months of March, September, October, November, and December 2014 up till date is unconscionable, vexatious, wrongful, and a breach of the contract of service employment. D, an order of this honorable court directing the defendants jointly and severally to issue the complainants and about 200 workers, such workers of the service dependent, letters of employment and reinstate them as staff and workers of service dependent. E, an order of this honorable court directing the defendant jointly and severally to pay complainant and about 200 other such workers their salaries, benefits, and entitlement for the months of March, September, October, November, and December 2014, January to December 2015, and January to June 2016, when they were ordered orally to stop coming to work, up to date of delivering judgment, in this case within 14 days of delivery of the judgment. F is 10% interest, monthly interest, 10% interest monthly on the salary, benefits, and entitlement of each of the complainant and about 200 such other workers beginning from the date of delivery of judgment up till when the entire salaries are paid. G, general damages in the sum of 5 billion naira against the defendant jointly and severally for the inconvenience, hardship, embarrassment, trauma, and damage suffered by the claimant as a result of the action of the defendant. H, cost of action at 5 million naira. The defendant filed memorandum of appearance and joint statement of defense on the 17th day of June 2024 out of time. However, by order of court, the processes were deemed properly filed and served. The claimants who are suing for themselves and on behalf of the abandoned and wrongfully terminated workers of Cross River State Management was testified as CW1, CW2, CW3, CW4, CW5, and CW6. In proof of their case, the claimants through CW1 tendered documents in evidence which were marked as Exhibit C1 to C25. Two other documents were also tendered. Other documents were also tendered through CW5. They were admitted and marked as Exhibit 5A, 5, CW5A, CW5B, CW5C, and CW5D. I will skip reading the case of the claimant, the case of the defendants. I will also skip reading the submissions of counsel. Yes, I now go to the court's decision. I have considered the processes filed in this suit, the evidence made at the trial, as well as the written and oral submissions of counsel for the parties. The claimants were employed by the seventh defendant, the Cross River State Waste Management Agency, between 2010 and 2014, without receiving formal letters of employment despite being promised. The claimants continued to work diligently for the agency and were paid salaries until 2014 when payment became inconsistent with several months salaries unpaid. In December 2015, the management team of the agency was dissolved and replaced, leading to the neglect of the claimants' employment rights. In June 2016, the claimants were orally instructed to stop coming to work, which effectively terminated their employment without formal notice or compensation for the unpaid salaries. The claimants staged a peaceful protest in March 2016 and wrote several letters to government officials seeking intervention for their unpaid salaries, but received no response. The defendants filed a defense out of time, which was deemed formally filed and served. In the defense, the defendants denied the claim of the claimants. The claimants, in their address, argued that their employment was terminated wrongfully and illegally and seek declarations and orders for reinstatement payment of withheld salaries and general damages and costs. The defendants, on their part, argued that the claimants were casual workers who denied the claimants of wrongful termination. They stated that the non-payment of salaries was due to failure of the claimants to submit login book, which will be used in paying them their entitlement. Though the defendants have admitted not issuing employment letters, they insisted that the claimants, by the nature of their employment, they are casual workers and not entitled to be issued with letters of employment. Both claimants and defendants formulated twin issues for resolution. The two issues are saying the same thing but worded in different words, but they were differently worded. In determining the dispute between the parties, I shall adopt the I shall in determining the matter before the court, I shall consider the issues formulated by the parties along with the facts of the case. I have earlier in this judgment captured the argument of counsel for the parties on the issues formulated for the termination. Therefore, there is no need to repeat the said submission here. I shall start considering the case by dealing with the preliminary issue of claimant suing in representative capacity. It is clear to me that parties are agreed that Order 13 Rule 1 and 12 and 11, Order 13 Rules 1 and 11 of the rules of this court are the relevant provisions governing representative action. For proper appreciation, the provisions are hereby reproduced. They have been reproduced in the body of the judgment. I will keep reading them. The rules as reproduced are very clear and unambiguous, and they say what they say. A thorough examination of these rules will show, as argued by counsel for the defendants, that all that is needed for the claimants to sue in representative capacity under the rules of this court is to indicate capacity in which the party is suing. In this case, the requirement has been fulfilled to show, as shown on the face of the processes filed before the court in commencing the suit. In the circumstances, I came to the conclusion that the claimant suit has satisfied the requirement of suing in representative capacity. There is no requirement in the rules of court for seeking or obtaining leave to sue in representative capacity. There is also no requirement for mentioning the names of the parties being represented, as it is not a requirement of the rules. This therefore has made Exhibit 3 CW5C and CW5D respectively, which indicated that the names of the persons that donated the authority to the claimant in this suit, the power to sue in representative capacity. The defendant has also raised objection to minutes of the meeting stated to be Exhibit C26. Let me say that the minutes of the meetings tendered before the court in the course of the trial were marked as Exhibit CW5C and CW5D and not Exhibit C26 as counsel for the defendant has referred to. As there is no exhibit mark as Exhibit C26. Also, contrary to the submissions of counsel for the defendant, these documents were pleaded in the reply to statement of defense filed by the claimant. See paragraph 3 of the claimant's reply to the statement of defense and paragraph 5 of the claimant's reply to statement on oath sworn to by the fourth claimant on the 9th day of December 2021. They were also front-loaded and attached to the reply, which was duly served on the defendant. Therefore, the submissions of counsel on pleading and front-loading minutes of meeting was misconceived. Counsel also argued that these minutes were prepared or made during the pendency of this suit. Therefore, they offend the provisions of Section 83 of the Evidence Act. This contention seems to have been made in error, as it is clear from the minutes that they were made on the 31st day of May 2018 and 8th day of June 2018, respectively. And this suit was filed on the 11th day of June 2020. Counsel for the defendant has also argued that Exhibit C14 Exhibit C14 payrolls for June and August 2014 are not signed were not signed and do not have any evidential value. Therefore, they do not have any evidential value because they are documents that were not signed, and the court should reject them. In response, counsel for the claimant argued that it is not all documents that require signature and date. Let me say that payrolls for June and August 2014 were marked as Exhibit C13 and C14 respectively. These documents are said to be payrolls for staff of the seventh dependent salary for the months of June and August. This means they are by virtue of Section 102 of the Evidence Act, public documents, in which only certified true copies of originals are admissible in evidence. A careful examination of the documents will show that they are photocopies and not originals or certified true copies. Therefore, these documents were ab initio admitted in evidence in error. They ought not to have been admitted in evidence, having not satisfied the requirement of the law on admissibility. The circumstances, these documents are hereby discountenanced for the purpose of this judgment. See the case of Onwago versus Atuma. I shall now consider the claim of the claimant as adumbrated by the relief sought as per the statement of facts. This is because in law, both the court and the parties are bound by the case put forth by the claimant, and no party will be allowed to deviate or change position midstream. The reliefs being sought are a mixture of declarations, order for payment of unpaid salaries, reinstatement, and damages. Let me point out here that the claimants in this suit were referred to as complainant by the counsel for the defendant in the processes filed before the court. However, I shall hereinafter refer to the complainant as claimant. I shall consider 1, 2, 3 together because they are related and interwoven. In release A, the claimant is praying for the court to declare the failure, refusal, neglect of the defendant jointly and separately to issue the claimants and the others be represented with letters of employment when they were employed as wrong and illegal, while in the second relief is for declaration that the defendant jointly and separately ordering the claimants and others be represented who are workers of the seventh dependent to orally stop work and thereafter abandoning them without work or any pay since 2016. And this is wrongful and illegal termination, and it is unconscionable, vexatious, wicked, wrongful, and breach of contract of employment. In relief 4, the claimants are praying for an order of court directing the defendant jointly and separately to issue claimants and about 200 others such workers letters of employment are reinstating them as staff and workers of the seventh dependent. From the evidence before the court, the employment of the claimants by seventh dependent was not in doubt, as the defendants have admitted existence of the claimant's employment with the defendant. It is also not in dispute that claimants were not issued with letters of employment by the seventh defendant when they applied for employment. They were interviewed and thereafter engaged orally and assigned duties. The failure of the defendants to issue letters of employment to the claimants when they were engaged is a clear violation of the provisions of Section 7, subsection 1 of the Labor Act that mandates the seventh defendant to open engagement of employee to within 3 months of their engagement issue claimant letters of employment stating the terms and conditions of the employment. However, the position of the defendant was that the claimants were engaged as casual workers by the seventh defendant. Therefore, they are not entitled to be issued with letters of employment. The position taken by the defendants that the claimant were casual workers was in clear conflict with the law. Furthermore, even if the claimants were casual workers, they have the right to be told in black and white that their employment was casual. There was no such evidence adduced before the court that the employment of the claimant has ended Therefore, the reason given for the non-issuance of letters of employment to the claimant is not tenable in law. The refusal and neglect to issue letters of employment to the claimant as stated by law was wrongful. There is no evidence before the court which in this case, the parties are not disputing that the claimants were employed by the seventh defendant and the employment was orally, and the said employment was equally terminated orally by the seventh defendant, the employer of the determination was effected when the claimants were orally asked to stop work and they were orally told that they have been sacked. This was in June 2016. This means the issuance of letters of employment as provided for in Section 7.1 of the Labor Act has been rendered redundant and overtaken by events since the employment relationships have been abruptly brought to an end, whether wrongly or rightly. Therefore, letters of employment cannot be issued in respect of a relationship that is no longer alive or in existence. To make such declaration, this means the issuance of letters of employment as provided for in Section 7 of subsection 1 of the Labor Act has been rendered redundant and overtaken by events since the employment relationship has been abruptly brought to an end, whether wrongly or rightly. Therefore, the letter of employment cannot be issued in respect of a relationship that is no longer alive or in existence. To make such declaration, will amount to the court imposing employees on an unwilling employer, which the law does not allow. See Kado versus CBN. The law is also settled that once employee complains that his employment has been wrongfully terminated, he has the onus to place before the court the terms of the contract of employment, and the onus placed the claimants have the duty to establish their complaint. It is not the duty of the employer as defendant in an action brought by the employee to prove any of these facts. See the case of Kado versus CBN. See Amodu versus Amoda. See also Iwechuku versus Uwezu. In the case at hand, there are no formal written letters of there is no formal written terms and conditions of service governing the relationship between the claimant and the defendant. This means this court, in determining the employment relationship, will resort to the common law principles governing master and servant relationship, since the claimant's employment does not have statutory flavor. It is where there is no mode for determination of contract of service by that it can be determined by in any form, with notice or without notice. The common law rule will apply in this matter, since there is no conditions of service. That is in this case, the claimants were told orally of their termination in June 2016. There is also no evidence from the parties to show if notice of termination has been given to the claimant orally, and the duration of the notice. In the absence of such notice given, I take it that the claimants were given notice of termination. This has rendered the termination of claimant's employment by the seventh defendant wrongful and not as wrongful only, and the court is not allowed to order reinstatement. The law is well settled that where an employer brings a contract of employment to the ID employment to an end by termination, if the employee effectively ceases to be an employee of the organization. The employee could not, at his own option, keep alive a contract of employment which has been determined by the employer. See Jumbo versus PFF. PEF Management Board versus PEF Management Board, reported in 2003 SC Part 2. It is to be noted that termination can be in writing or oral. What is What is important is the demonstration by the defendant of his desire to continue with the services of the claimant. By the conduct and actions of the seventh defendant, from the evidence it is in evidence that as from the date the claimants were asked to stop work and that their contract of employment or employment has been determined, the defendant ensured no work was given to them. The claimants were also prevented from gaining access to the premises of the seventh defendant. This clearly and conclusively points to the fact that to the fact of termination of claimant's employment by the seventh defendant. This led them to the claimants writing several letters of Save Our Soul to the writing several letters of Save Our Soul to the governor, deputy governor, secretary to the government, and other government agencies and human rights commission, relief 3 commission, but all efforts of the claimant did not yield any result in ensuring claimants were paid their unpaid salary. See Ipeta versus Shell. Relief 3 and 4 would be considered together. In relief 3, the claimants are seeking for a declaration that the failure, refusal, and neglect to the dependents jointly and severally to pay the claimants and other workers in relief 3 and 5. The claimants are praying for payment for an order directing the dependent to pay their unpaid salaries up to June 2016 and thereafter up to date of judgment until liquidation. In this case, the claimants it is clear that the claimants are claiming for unpaid salaries from the defendant. Counsel for the defendant has in paragraph 3.31, 3.32, 3.33 of the defendant's final written address refers to exhibit C2, C3, C4, C16, C17, C18, C20, and C22, and pointed out discrepancies regarding the exact months claimants were to be paid salary. Counsel submitted that the claimants have not established the exact month with which they are making their claims for salaries before the court, as the exhibits they have tendered are not in their favor. Counsel also submitted that entries of work done were supposed to be put down in logbook in the custody of the claimant. It would be used to calculate their proper entitlement. The default in compliance in compilation of the work carried out, which resulted in the confusion about their emolument. Claimants have not brought any entry of work done and pay the courts have provided guidelines on how to determine payment of salaries. In the case of Honica versus Sawmill Nigeria Limited, it was stated that as between the employer and employee, the onus is on the employee to prove that employer employed him on a stipulated salary and that he worked for the employer during the relevant period. It is for the employer to prove not only that it has paid the employee his salary for work done by the employee in the relevant period, but also how much the salary for work done by the employee in the relevant period, but also how much the salary that he paid to the employee. For the claimants to succeed for the claimants to succeed in their claim for salaries and the above burden of proof establishing the claimants have a burden duty of establishing that on a stipulated salary he was employed on a stipulated salary and that they have worked for the dependents for the relevant period they are claiming salary for. It is after discharge of this duty that the onus of proof will shift back to the claimant. In this case, there is no consensus that claimants were in this case, there is consensus that the claimants were employed by the seventh defendant. The area of dispute between the parties is regarding the payment of unpaid salary, but there is no dispute as regarding the employment of the seventh dependent. Employment of the claimants. The only dispute between the parties is the issue of salary and paid salaries for the period covered by the exercise. The dependent in their response attributed non-payment to failure of claimants refusing to make available to the dependent logbook, which according to the defendants, the defendants insisted that the logbook is what is required for them to ascertain the exact amount claimants are entitled to. The claimants insisted that the defendant do not need any logbook for the claimant insisted that the defendant do not need any logbook for the calculation of the salary. The claimants also debunked any suggestion that their pay is on daily basis. They insisted they are paid on monthly basis, and DW1 confirmed that the claimants are paid on monthly basis, but on number of days. It is strike law that for arrears of salaries, are claims that fall within the purview of special damages claims. And by law, they are required to be specifically pleaded, particularized, and strict proof also is required. In the case at hand, from relief 3 to and 5, claimants and every one of them is entitled to. There is also no particulars as to whom the salary was paid. There is no particularization, and the claimant in response to the argument of counsel for the defendants regarding non-proof of entitlement or salaries, counsel for the claimants refers to Exhibit CW 5A and submitted that this exhibit is enough to prove unpaid salaries of the claimant. Counsel asked the court to utilize Exhibit CW 5A in coming to the conclusion that the claimants have proved there are various amounts they are entitled to as their salaries. It is clear to me Exhibit CWA being relied by the claimant in proof of their claim for unpaid salaries is not capable of proving the said claim. The reason being that it is a document of the claimant prepared by the claimant for the purpose of this suit. See the last page signed by the first and second claimant. This document, being handwork of the claimant, does not have evidential value. From its heading also, it portrays that it belongs to the defendant, when in actual sense, it was the document of the claimant. Furthermore, the document is undated. The law is settled that undated document does not command any evidential value. Therefore, this document is, as far as this suit is concerned, is worthless document without any weight to be attached to it. See the case of Mr. Yoris Bigioni versus Mrs. Tina Brahamas and another, where the court held that as an undated document was held to be invalid and has no probative value. See also the case of Baho versus Regis Street of CC. See also the case of Balion versus registered of CCB. At whatever angle this case would be looked at, the way failed to by documentary evidence prove entitlement to the grant of unpaid salaries due to lack of proof of the quantums of the salaries to be awarded to them. Let me point out here that the law is well settled that claims for salary and other employment terminal benefit entitlement are indeed categorized within the sphere of special damages claims. In law, special damages are those damages that are quantifiable and must be specifically pleaded, particularized, and proved strictly before grant is made by the court. They are distinct and they are distinct and distinguishable from general damages which are presumed by law and do not require any specific pleading. See the case of ACB PLC versus NBCK. See also EcoBank versus First Choice Properties and another. Therefore, the claimant in this case, basing their claims on pension, basing their claims on unpaid salaries, is a claim for special damages which by law imposes a burden on them to demonstrate the exact amount owed and also the basis for the claim and how the claim was arrived at. The Supreme Court in the case of Union Bank versus Nwanko and another highlighted the burden of proof on a claimant to prove special damages, emphasizing that such damages cannot be awarded based on speculation. Similarly, in the case of Attorney General of Abia State versus Attorney General of the Federation, the same apex court reiterated that special damages must be specifically pleaded and strictly proved. In the present case, the claimants, having failed to heed to the admonition of the apex court, they failed and neglected to specifically plead, particularize, and strictly prove their claim. They have not proved entitlement to payment of unpaid salaries. In the circumstances, the claimant apart from in the circumstances, the claimants have failed to prove exact amount being claimed as salary to make matters worse. The claimant did not establish what their monthly salary was when they are in service. In view of failure of the claimants to prove the quantum of their claim, I have no choice than to come to the conclusion that they have not proved their salaries to be paid to them. I should not be misunderstood here. What the claimants fail to prove is the salary, but not that they are not entitled to be paid their salaries. The defendants have not disputed the entitlement of the claimants to unpaid salaries. Their quarrel was there was confusion, which make it not possible for them to compute the same claim. The claim for confusion has not been established as it is based on ipse basis of the witness. The defendant should have tendered documentary evidence used used in calculation and which resulted in the said confusion. They have not done that. The counsel for the claimants has also stoutly argued that the defendants refused to issue letters of employment to the claimants violated the provisions of Section 7 subsection 1 of the Labour Act, and also argued that the refusal to pay claimants' salary is also in violation of the Labour Act. Council submitted that these infractions amount to an unfair labor practice. I have earlier in this judgment found that the defendant's conduct in not issuing letters of employment to the claimants and not paying them their salaries as and when due are all clear infractions of the provisions of Section 11 and 15 of the Labour Act. The defendants cannot be allowed to hide under the canopy of self-created confusion or alleged failure of the claimant to submit logbook to continue to deprive the claimant their hard-earned salaries. It is the duty of the defendant to keep and maintain a record of payment of salaries to their employees. The claimants have abandoned the conduct of the defendant in denying them letters of employment and salaries. All have dramatized them and make it difficult for them to even pay for their children's school fees. What is even surprising is that from the evidence of DW1 under cross-examination was asked about when the issue will be resolved. He informed the court that he does not know when the issue will be resolved, and he does not know whether it can be resolved. This is a clear indication that the defendants have no intention of paying the claimants their salaries. That's why they keep tossing the claimants from one pillar of the goalpost to another. And the claimants have not helped themselves by failing to prove also what is their salary and the exact amount they are entitled to as their salaries. In view of all what I have said above, I am convinced that though the claimants have not been able to prove their unpaid salaries, they are entitled to, they have nevertheless been able to establish unfair labor practices as a result of the defendant violation of clear and unambiguous provisions of the Labour Act. As a result of the defendant's violation of the claimant's violation of the clear and unambiguous provisions of the Labour Act, the defendants are engaged in unfair labor practice in the circumstances and in the exercise of the powers conferred on this court by virtue of Section 14 and 19 of the National Industrial Code of Nigeria 2006. I hereby declare that the claimants are entitled to compensation for the unfair labor practices by the defendant against them. Regard and unfair labor practice through denial of their salaries and making life uncomfortable. In the circumstances, I hereby award 30 million naira as damages for compensation for the claimants the relief 6, which is for the sum of, which is for 10% interest on monthly on the salaries benefit, is not grantable as it depends on the grant of the payment of salaries which has not been succeeded. This relief being dependent on the other relief also fail. Monetary on the whole, and from the finding of the court, and from the finding of the courts regarding unfair labor practices, this court award compensation in the sum of 30. This sum shall be paid within 30 days from the date of this judgment, failing which interest of 10% shall apply per annum. I also award 500,000 naira cost against the defendant in favor of the claimant. Judgment is hereby entered accordingly. Yes. Thank you very much. I wish you sir. It's all right, you are welcome. Call the next case.
Between 1, Fire, 2, John Abba, 3, Joseph, Josephine, 4, Samson, the son, 5, Sylvester, Samuel, 6, Gabriel, Amani, 7, Vincent, Isua, 8, Lucas, Omanokwa, 9, David, Ayabe, 10, Augustine, Obute, 11, Godfrey, and 1, Obudumabe Resort, 2, Hotel Hotel, Obuduran, 3, Mr. Julius Matthew, Acting General Manager, Obudumabe Resort, 4, Mafran Abu, Senior Advisor of Obudumabe Resort. My Lord, parties are absent.
Appearance. Appearance. Yes. Yes.
Appear for the claimant.
Yes. Any other appearance? Yes.
All represented. More than 80 defendants in the Lord orders, if we got them.
You said?
The 8 defendants in court.
8.
Yes, sir. The amount in court. The defendant the 8 defendant is in court.
And he did not stand up when they called. Since he did not stand, I have already written parties absent. I can't change my record. It's his fault. When they called, he should have stood up and or raise his hand. Yes.
The matter was the day for
Yes.
unfortunately, my account of health.
Yes.
We took on brother. We were not involved in politics.
Give me that.
Remember the
I done some cases yesterday to that day. Don't go and talk the place. Huh? This case is hereby adjourned to 28th day of October 5 for cross-examination and continuation of hearing. Hearing notices to be issued and served on the defendants. Proof of service to be kept in the case file.
And one, the general manager, Cross River State was subordinated. Two, Cross River State was subordinated. Three, government of Cross River State. My lord, the claimant in court, defendant,
Appearance. Appearance.
We come not representing.
Yes.
It will be my lord. Appear for example.
Yes. Any other? Yes. Any other appearance? Yes, counsel. Yes. Yes. You remind him he is already a witness. Yes.
Yeah. We told that, and the class had done it. You are talking about the law. And it's document. Also, the witness statement on the amended statement of fact. In your paragraph 6, you pleaded face leave of the face leave of the head defendant.
Yes, my lord.
Take a look at this case. Witness to tender 35 people of your investigate. Leader in paragraph C of the amended statement of facts. And mark as if that project in compliance with the directive. I think it is for the thing.
The documents ought to be tendered in evidence is hereby admitted in evidence and marked as exhibit C20.
And the property. Yes, witness. You also in your paragraph 5
Yeah.
of your amended statement of fact, make reference to your
Mr. Obi, you are not new in this court. You can't be tendering document in this mill, please.
This one is only needed. Make reference to it. This is custody of the third defendant. Do you want to affirm that paragraph?
Doesn't need to affirm anything. He has already adopted his witness statement on oath. So if it has been stated there, but this is a photocopy, the original is with the defendant, and this is what we are relying on, that will suffice.
I'll not be more the witness.
You are not tendering the document again?
It is in custody of the third defendant. And every effort to get that, prove the about
No, you have not done what you are supposed to do. You would have gotten it. Yes, that is not enough. That is not enough for you not to tender it. Can't you subpoena them to come and bring it?